Good afternoon, everybody. I am back, and I am your host, the Supreme Litigant. I'd like to thank everybody who has subscribed to my channel. If you haven't already, please do me a favor and go ahead and hit that like button and that subscriber button. I'll give you a second to do that. All right, now let's get to it. I got a question today from somebody who subscribed to my channel, and I'm guessing that they are having issues with understanding how to draft the ultimate facts section of your complaint. So I'm going to use my complaint as an example, and I'm going to explain to you the reason that I made each of these allegations in the facts section, aka the ultimate facts section of my complaint. And I'm going to tell you why I said what I said. Okay. But first, before I do that, I'm going to go here because I want y'all to understand something. Okay. This is what you need to study. This is the common law right here. This is the common law. This is how you would know if you have been seized within the meaning of the Fourth Amendment. A person has been seized within the meaning of the Fourth Amendment only if, in view of all of the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. You see this number right here? There's a footnote. If you go down here, this is the Supreme Court case where they got that conclusion from. That's the case right there. Okay. In my complaint, that is what I said. I basically said at this point in particular time, plaintiff felt that he was not free to leave. So let me just go ahead and go straight into the facts section of this complaint. Number one, you want to explain to the court to the best way you can the date, month, and time that this happened. Because what that is going to do is that is going to place that officer exactly right where you said she or he was on this particular day and time. That's what that allegation right there is going to do. And what they're going to do is they're either going to admit that this happened on this day or not, or they're going to deny that it happened on that day or not. They're going to do that for everything in this entire complaint, not just your facts section. They're going to do that for everything in here in this entire complaint because they're trying to narrow down the facts of the case so the judge can go ahead if it's warranted to go ahead and apply the law, the relevant case law to the facts of the case and determine if these facts are sufficient to justify you suing this police officer. Okay, so I'm giving y'all the story now. Just also keep in mind this. There are some other facts that did happen on the night of this incident, but I did not talk about them at all because they are irrelevant. They're not going to prove my point on why I sued these police officers. So I left them completely out of this complaint like they never even happened. And that is what you need to do. If it's irrelevant, if it's not going to prove your point, do not talk about it, period. So let's go right here. I'm explaining to the court where I was going. Plaintiff was heading home from work when his automobile completely shut off as it was still in motion. Okay. I'm explaining this to the court. Said highway had no shoulder to safely park. So the purpose of this allegation was to let the court know that my car had shut completely off. And I was, as the car had shut off, it was still in motion. I probably was going maybe about 30 or 40 miles per hour, something like that. But as it's going down the road, all of the lights on my car had shut off. The car was just completely dark, and it's still in motion. So I was looking to see if I could safely park this car. Okay, so I could not cause any types of hazard or something like that, which is the reason why you see this allegation right here. In an attempt to not block or cause a wreck from ongoing and coming traffic, plaintiff managed to successfully park and minimize as much of the hazard as he could. I acted reasonably. Do y'all see what I'm saying here? I was acting reasonably based on these allegations right here. Based on when I said my car had completely shut off as it was still in motion, and this highway didn't have any shoulder for me to safely park. And I explained to the court In an attempt to not block or cause a wreck from ongoing and coming traffic, plaintiff managed to successfully park and minimize as much of the hazard as he could. I acted reasonably. I was acting reasonable. On to the next one. Plaintiff then gets out of his automobile and turns the bright light from his cell phone on to warn oncoming and ongoing traffic of this hazard. I want y'all to understand that. All right. About 5 to 10 minutes later, a Chickasaw police officer by the name of Brandon Breland flashes his police lights, stops his patrol car, and then exits same. I'm telling you what he had. This is what happened. It happened just like this. Yes, there was some other stuff that happened, but keep in mind, it's irrelevant. I didn't talk about it. So you're not going to even see it in here. I'm not going to even talk about it no more. I'm not going to even say that no more in this video because it's irrelevant. On to the next one. Brandon then walks over towards plaintiff and requests, notice I said request, not order. He requests plaintiff's ID. The reason why I use the word request here is because I am not lawfully detained. Okay, they can only issue lawful orders. Okay, lawful orders, and they get lawful orders if they have lawfully detained you or lawfully arrested you. It's going to always be based on the facts and circumstances of the case. So he requested my ID. That's a request. I don't have to comply. That is a request. I don't have to comply with that. Plaintiff then replied, for what? Breland then replied, because you're broke down in the middle of my highway. Do y'all see that? That statement right there. When he said that statement right there, I automatically reasonably concluded, based on what he said, that was a request, not an order, and I did not have to comply to him because being broke down in the middle of the highway is not a crime. Do y'all see what I'm saying here? Which is the reason that I said this. After witnessing this verbal statement made by Breland, plaintiff then declined to give Breland his ID, but did give Breland his first name. Y'all see this? This shit is so simple. So simple. So simple. Only you know the facts of your case. So who better to argue your case better than you? I'm going to get y'all right. I'm going to get y'all motherfuckers right. They're going to put you on the do not detain list if you keep listening to me. And every time they mess with you, it's going to cost them 5 figures or more. It's going to cost them. Breland then walks off and calls for backup. Okay. About 5 to 10 minutes later, 2 more officers by the last names of Holyfield and Morgan of the Chickasaw Police Department arrived in their police cars. Morgan is about 6'3" to 6'5" in height and weighed about 230 pounds or more. The purpose of this statement right here about Morgan was I kind of really didn't remember how he looked, but I just remembered his features as far as his height, his race, and the amount of his weight, his body weight that he weighed. So if I saw somebody in Chickasaw that was a police officer about this height or whatever and that weight, and they were black, then I could reasonably say, even though I could possibly be wrong, but I could reasonably say that was Morgan. On to the next allegation. Plaintiff was then approached as his back was against his automobile, surrounded by Holyfield, Breland, and Morgan, and demanded to show his ID once again in a more aggressive tone. Okay, this allegation right here, with a reasonable, let me ask you something. If police officers did this to you, if they approached you as your back was against an automobile, surrounded you, and then demanded you to show your ID once again in a more aggressive tone, in a tone more aggressive than the first time, would you feel like that you're free to leave? Your back is against your back is against the car, so you can't run. They're asking you to show this again in a more aggressive tone. Okay, that's one allegation. Plaintiff then saw Holyfield with his hand on his gun, and at this time and at this point was certain he was not free to leave. Based on these two allegations right here, 22 and 23, I reasonably concluded that I was not free to leave. So I'm going to stop right there and I'm going to go right back to here. A person has been seized within the meaning of the Fourth Amendment only if, in view of all of the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. A reasonable person assesses the area and it is based on the facts. Okay, let me go right here. This is what this court said right here. In this case, I didn't read this whole entire case, but when I saw this was just funny to me. The majority would have us believe that De La Rosa, blocked in by police vehicles that followed him through a locked security gate and confronted in his own parking lot by armed agents who demanded and retained his most valuable piece of personal identification, would feel free to walk away blissfully. I'm sorry, y'all. This is so funny to me because the court is being sarcastic. So I'm gonna read this again because this is just so funny to me. I can't. I'm messing up my words because I'm trying not to laugh because this is so funny to me. So I'm gonna do this one more time. I'm sorry, y'all. The majority would have us believe that De La Rosa, blocked in by police vehicles that followed him through a locked security gate and confronted in his own parking lot by armed agents who demanded and retained his most valuable piece of personal information, would feel free to walk blissfully away from these officers and continue on his own business. That is just so funny to me. So let me get back to this. Pay attention to that reasonable person thing right there, because that applies to that applies to detentions and arrest under the Fourth Amendment. So let's go back to my complaint. All right. We're on 24 right now. Plaintiff then replied again, for what? Plaintiff was then intentionally grabbed in a rude, aggressive manner by his arms as both arms were forced behind his back. I want y'all to pay attention to this right here because this is the definition. This is an element of an assault. No, let me rephrase that. That is an element of battery. I'm sorry. If they grab you in a rude, aggressive manner, the manner that they grab you, that is a battery. Just to let y'all know. They unlawfully touched me in a rude, aggressive manner. That's that element right, that allegation right there, that fact right there, that averment right there, that contention right there is an element of battery. Okay, and these facts right here, I'm gonna go back up. 22 and 24, that is an element, or these facts right here proved that a reasonable person in my situation would not feel free that they can leave. If this makes sense to you, I'm sorry, I'm kind of talking too fast or whatever, because I'm trying to talk faster than I can think. So that's why I'm doing that. I'm sorry. All right. Plaintiff was then handcuffed, searched about his person, and then informed that he was being detained. This is another element. This fact right here. This is another ultimate fact. This is another allegation. This is another contention. This is another averment of battery and assault, by the way. Plaintiff's wallet was then taken to Breland by Holyfield, and then Breland walked towards his patrol car contacting dispatch for a warrant check as Morgan and Holyfield continued to detain plaintiff. See that? That's private. That wallet right there, that is private property. That's a personal effect. And you took that without no lawful purpose whatsoever, and you unlawfully detained me. You got to pay for that, man. You have to pay for that. So I'm being very detailed with these allegations, okay? Because I'm detained. I know I'm detained right now. That's why you see me use the reason you see me use the word detain Later down here is because I said this right here. Plaintiff then saw Holyfield with his hand on his gun, and at this time, and at this point was certain he was not free to leave, which means I am detained or I am seized within the meaning of the Fourth Amendment. I just used the word detained because I knew I was detained and not arrested, even though I'm not going to even say that because I don't want to confuse y'all. Plaintiff disagreed with Holyfield, Breland, and Morgan's actions against him, but did not resist because fear of possibly retaliatory criminal charges, excessive force, death, or all. So I'm explaining to the court that even though I disagreed with their actions, I didn't consent to this, because you can consent to being detained and you can consent to being arrested without probable cause. You can consent to being detained without reasonable suspicion. That's lawful. You can do that. So that's the purpose of this allegation right here. All right. And also the purpose of this allegation right here, 27. So I'm letting the court know that they basically detained me to just to ID me and to see if I had warrants or anything like that. That was the purpose of this allegation right there. And you can't do that. You can't just walk up on somebody and detain them without reasonable suspicion. You can't do that. That's unlawful. You cannot do that for a warrant check. That's unlawful. I know that. They should know that. A reasonable officer would know that. What I am doing here, y'all, all of these facts show that a clearly established, constitutionally protected right has been violated, of which a reasonable officer would have known, which means they don't get immunity. That's why when their attorney answered this complaint, he did not file a motion to dismiss on qualified immunity grounds at all. He filed a shotgun pleading because my complaint was just that good. Anyway, right here, I'm letting the court know right here, neither Holyfield, Breland, nor Morgan have filed criminal charges against plaintiff thus far. Do y'all see this right here? None of them filed criminal charges at all, period. Period. This allegation right here proves my point that I was unlawfully detained just so I can be identified for my ID. I'm sorry, just so I could be identified and to see if I had any warrants. They basically just profiled me, is what I'm trying to say, because I didn't want to give them my ID. They thought I had something to hide, because I didn't want to give them my ID, when in fact I didn't want to give you my ID because I don't have to give you my ID. All right. After Breland was notified via dispatch that plaintiff had no warrants, the handcuffs were removed from plaintiff's wrist. This right here, this is it right here. This is going to take away all of their immunity right here. This is a wrap. Holyfield, Breland, and Morgan at all times herein acted under color of state law, negligently, gratuitously, willfully, and beyond their authority with the intent to injure plaintiff. It's a wrap. You see, now all of the, even though this is a conclusion, this is what you call a conclusion, okay? But you can't make conclusions without facts. The reason why you see this conclusion right here last is because I have all of these facts up here that I just went over to show y'all. So you are allowed to make legal conclusions when you have facts to support those conclusions. They call them inferences. That's what they call them. So it's really the same thing. And then, paragraphs 1 through 31 are incorporated herein by reference and predicated on reasonable inferences. In other words, reasonable conclusions from these same allegations up here. That's what that means. That's it, y'all. That's it. So this is what I proved. These are my causes of actions based on the facts that I alleged above, because I know when my rights are violated, because I study law. Don't read no statutes. Go and read cases. The judges are going to tell you what your rights are. They're going to tell you all of the elements, in other words, the facts that you need to allege a valid cause of action. Let me stop right there and go right here. I'm going to read y'all something. Material facts are those ultimate facts that constitutes the elements of a cause of action or affirmative defense, sometimes referred to as elements facts. Let me see. I'm gonna try to read something. Y'all can go and read these cases if y'all want. The elements of a cause of action constitutes the essential or ultimate facts in civil case. I'm sorry, in a civil case. Ultimate facts are distinguished from evidentiary facts and from legal conclusions. Okay? These are your ultimate facts. Right up here. All of these allegations where it says facts at right here. Let me go up some more. I want to show y'all this. I'm sorry. Right here. 9 through 31. Those are your ultimate facts. All right. So this is my first cause of action. Plaintiff avers his right. I'm sorry. Let me read this again. I'm trying to read too fast. My apology, y'all. Plaintiff avers his Fourth Amendment right to be secure in his person against unreasonable searches and seizures as guaranteed by the Fourth and 14th Amendments of the United States Constitution was violated whereby plaintiff was unlawfully detained. As a direct and proximate result of Holyfield's, Breland's, and Morgan's acts and omissions jointly and severally against plaintiff, plaintiff has suffered injuries to his person. It's a wrap. That's it. You have to allege this as a direct and proximate result of them doing everything that I said that they did in those ultimate facts section. Plaintiff has suffered injuries to his person. Second cause of action. Plaintiff avers his right to be free from unreasonable searches and seizures as guaranteed by the Constitution of the State of Alabama, Article 1, Section 5, was violated whereby plaintiff was unlawfully detained. As a direct and proximate result of Holyfield's, Breland's, and Morgan's acts and omissions jointly and severally against plaintiff, plaintiff has suffered injuries to his person. Simple. False imprisonment. Plaintiff avers that as a result of his Fourth Amendment right to be secure in his person against unreasonable searches and seizures, as guaranteed by the Fourth and 14th Amendments of the United States Constitution, and his right to be free against unreasonable searches and seizures, as guaranteed by the Constitution of the State of Alabama, Article 1, Section 5, being violated, Holyfield, Breland, and Morgan thereby subjected him to false imprisonment, whereby unlawful detention. As a direct and proximate result of Holyfield's, Breland's, and Morgan's acts and omissions, jointly and severally against plaintiff, plaintiff has suffered injuries to his person. What type of injuries? Now, if you want to, you know what, we're just going to focus on this because I don't want to throw y'all off, so I'm going to just focus on this. Assault and battery. Plaintiff avers that defendants each touched plaintiff and intended to touch plaintiff to effectuate his unlawful detention, and therefore, as a matter of law, committed an assault and battery upon plaintiff's person. As a direct and proximate result of Holyfield's, Breland's, and Morgan's acts and omissions, jointly and severally against plaintiff, plaintiff has suffered injuries to his person. Now, they have to, them touching you in regards to assault and battery, they have to intend it to, like, they have to be, that the touch has to be intentional. Okay, they can't just mistakenly do it and then you try to get them with assault and battery, because an element for the assault and battery, it has to be intentional, if I'm not mistaken, which is why you see that in there. Right here, negligent involvement in unlawful arrest, and this is a cause of action that was recognized by the 11th Circuit. Plaintiff avers that defendants each possessed actual knowledge that there was no constitutional basis for them to arrest plaintiff when they arrested plaintiff, and therefore, as a matter of law, committed the tort of negligent involvement in unlawful arrest. Just to let y'all know, in a detention is an arrest, even though you're not in jail. It's an arrest. Let's see. Upon plaintiff's person, as a direct and proximate result of Holyfield's, Breland's, and Morgan acts and omissions jointly and severally against plaintiff, plaintiff has suffered injuries to his person. I'm hurt. I might not be physically hurt. I might just be mentally hurt. It don't matter. You got to pay for that. I'm traumatized by what y'all did to me. I'm so damn scared now that every time I see blue lights coming through this city, I pull over to the side of the road because I'm having a damn anxiety attack. It's so fucking bad. I'm just giving y'all an example. This shit ain't hard, man. Y'all can do this shit, man. Hopefully this video helped y'all. Hopefully. If it didn't, let me know and I'll try another approach. Okay. Hopefully this helped y'all though. Don't talk about nothing that does not prove your case. Period. Period. That'll be the end of this video. Wait a minute, hold on. I think there was something else I wanted to talk about. Did I? I don't know. I might have lost it. Probably did. I think it was this. Let me see. I'm going to read some more of these. How long was this? Where I'm at right now, 25 minutes. Okay. In order to plead a cause of action, the pleader must allege ultimate facts from which the fact finder, meaning the judge or the jury, can conclude the essential elements of the cause of action. I'm sorry. I'm reading too fast. Can conclude the essential elements of the cause are present. Let's see. Ultimate facts are the final facts required to establish the plaintiff's cause of action or the defendant's defense, and evidentiary facts are those subsidiary facts required to prove the ultimate facts. One is not required to plead the ultimate facts that support the elements of the claim of the cause of action, but facts sufficient to appraise the defendant of the incident must be included in the petition in order to provide fair notice of the claims asserted. I'm just let y'all know. You see how he's using this word claim? That word claim. Let me tell y'all something. These people have insurance. I call it tort insurance. They have insurance. At my settlement conference, there was a woman there. I did not know who this woman was. I've never seen this woman ever in my life. There was the judge, their attorney, my defendants who I had sued, and their attorney, and there was this woman there. This woman, y'all are probably gonna laugh at me when I say this, but this woman was the insurance adjuster for the police officer because, like I said, they have tort insurance. So let me go and show y'all what I'm talking about. It's called, they call them, let me go to Google. And I'm going to show y'all what I'm talking about. It's the Alabama Municipal Insurance Corporation. There we go right there. These police officers had insurance. Alabama Municipal Insurance Corporation. Okay. That insurance company insures claims against these police officers. They indemnify these police officers is what they do. So when I sued them, they had to let their insurance company know that a lawsuit has been filed against them. So I say that to say this. This shit is all a game, man. These people, this is no difference than when two people on the road, they have a car accident or whatever, and they go to exchanging information and exchanging insurance information and stuff like that. That's exactly what this is. That is exactly what this lawsuit is. You're filing a claim. It's like you filing a claim against a bond or something like that. Because they, like I said, they have to let their insurance company know. And if y'all don't believe me, if you in Alabama, call that number right there. Call that number tomorrow. And if you get anybody on the phone, you should get somebody on the phone. It's not hard. If you get anybody on the phone, ask that woman or man, whoever you talk to, how many cities of the state of Alabama does this company insure? And they're going to tell you anywhere between about 95 to 98%. They're corporations, man. All of these motherfuckers are corporations, and they have insurance. This is their insurance. I have a copy of the policy on my computer, their insurance policy. They have I want to say it's 4 million. I think it's $4 million per claim that they insured up against. I think that's their max. I have a copy of it on my computer. I can't show it to you because it's confidential. Crazy, right? But I have a copy of it. But it's just the fact that I have it, and the fact that I never knew who that lady was, y'all, and I always wondered who she was, and now I get it. She's the insurance, like she's their agent. She represented them. She was in there with the judge, their attorney, and her clients who I had sued. They were negotiating the settlement. Yep, that's what it was. That's exactly what it was. But anyway, that'll be the end of this video, man. Hopefully, it wasn't too long. Yeah, that is kind of long. But anyway, I would advise y'all to at least watch 30 minutes of this video. But that'll be it. Everybody enjoy your day. The Supreme Litigant is out. Peace.